All right, Norm and Thomas, I am showing 12:01. Are you ready to get started?
Absolutely.
Are y'all confirming everyone can still see my PowerPoint on the screen? Great. All right. Well, good afternoon, and thank you for joining us for the second installment of our Special Asset Summer School Series. This class is led by Norman Leonard and Thomas Wolff, and we're going to be talking, well, not we, they will be talking about special topics and collections, foreclosures, and workouts. I'm Haley Cook, Marketing Coordinator of Events and Proposals here at Warren Smith, and I'll be your moderator this afternoon. Just wanted to go over a few housekeeping things with you. If you have any issues with video, Zoom, or sound quality during the presentation, please reach out to me please reach out to me using the Zoom chat feature, and I'll try and troubleshoot with you. This webinar is being recorded. Check out our website for past webinars. There's a website, past webinars tab on our website. If you missed this, there will also be a link tomorrow when I send out the slides as well. Our speakers are happy to take questions during this webinar. If you have a question, please type it in the Q&A box and it will be addressed at the conclusion of the presentation. As I mentioned, our speakers today are Norman Leonard and Thomas Wolff, both creditors' rights attorneys. Norman is in our Asheville office and Thomas is in our Raleigh office. And I am going to turn the microphone over to Norman, so to speak.
Thanks, Haley. All right. Good afternoon. As Haley said, my name is Norman Leonard, and I'm in Ward Smith's Asheville office. I've been practicing creditors' rights law here for about 15 years now. I'm joined today by my colleague, Thomas Wolff, who's been practicing creditors' rights law and bankruptcy law in our Raleigh office for about 8 years now. And today we're going to cover some basics in the areas of foreclosures and deficiency judgments, voidable transactions claims, and claims to pierce the corporate veil. Just a brief disclaimer, as I'm sure everyone attending is aware, this is just a brief overview of some of the basic concepts and issues in these areas, and it's not intended to be legal advice. Every factual scenario that you will encounter in your day-to-day is going to be different, so please consult with your own legal counsel if and when you are confronted with an issue in one of these areas. Okay, with that said, I'll hand the presentation over to Thomas to discuss foreclosures and deficiency judgments.
Yeah, thanks, Norman. Thomas Wolff here. Happy to talk a little bit about foreclosures and deficiency judgments. This is meant to be sort of a primer on the subject and kind of go over some of the legal and practical considerations that we take a look at the front end of a file when there's certain situations, depending on what the collateral is, do we have real and personal property collateral? Is everything oversecured or undersecured? And these sorts of issues that pop up along the way. So I want to give a good rundown of sort of some of the things that we look at on the front end to assess and go over and try to roadmap out a good strategy to help alleviate a lot of the headaches along the way, try to simplify the process, and also, of course, maximize the chances of recovery by applying pressure with deficiency judgments as well. So without further ado, kind of the first step we look at when we get into these things is we want to assess the collateral. What are we talking about here? Do we have real property or personal property, or do we have a mixture of both? Depending on what we are talking about is going to affect whether or not you file a non-judicial sale, the normal foreclosure action you think of when you're recovering real estate from a borrower, or do you want to use a judicial action where you go before the judge to obtain a judgment or possession of the property that way, or you can use both in conjunction, which is what we're talking about here. Is this debt a commercial debt or a consumer debt? The limitations and the restrictions in each of those processes can be quite different depending on who it is we're dealing with. Is this an individual borrower that borrowed the money for their own home? Is this a mortgage loan, or is this a commercial debt? And you're left with a vast amount of collateral in addition to the property. Maybe the fixtures in the building. Maybe there's other concerns. Maybe it's a gas station that has environmental concerns because there might be tanks buried in the property. Um, is there a tenant in place? Do we have to take a look at an assignment of rents? Is it possible to start picking up those rent payments while this process goes, through the courts? Sometimes these foreclosures can be short. Sometimes it can be a long drawn out process. And so maybe you want to take a look at the rent provisions first. If this is personal property we're talking about, is it something that's easily moved, or is it fixed in place? If talking about a restaurant that has walk-in coolers as the collateral is a whole lot different to try to recover than if we're talking about a fleet of vehicles that sheriff can easily pull up with a rollback and start picking up its collateral. Is the equipment something that is a specialty item, a niche market? Is this specialized equipment that only very few people have an interest in buying? That's going to take into consideration whether or not we can easily move it, whether we can put it on the market and sell it, or do we have to be a little more direct with our approach on how to get that collateral out of the bank's hands once we do pick it up. We also want to look at where it is. A lot of the laws will restrict where we file our actions. If it's real estate, we have to file our action where the property is located. When it's personal property, we have a little bit more flexibility. We can file in other locations and seek recovery of that personal property collateral by moving a judgment there sometimes. In other cases, you're going to be restricted to where it is. And so we got to take a look at where the majority of that collateral is before we start filing things with the courts. Is this a highly depreciable asset that we're dealing with, or is there a risk that the borrower may be trying to move this out of our reach and try to hide it on us? There are pre-judgment remedies also available when we're talking about personal property that we can consider. If we think that this is a piece of equipment or some other asset that the debtor is going to take away and secrete so we can't get our hands on it and just try to frustrate our efforts, there's an attachment process we can do immediately when filing a complaint will allow us to get our hands on that collateral by court order and hold on to it until the case concludes, when it can be liquidated and applied to the judgment. So you don't always have to just sit and wait for the process to go through. There are ways to do that, although you have to have a good showing that there's a likelihood they're going to take that collateral. Most importantly, is the collateral or the security interest properly perfected and secured? You don't want to overlook that fact and find your way halfway down the road and realize you got a problem with clouded title. Were the documents signed by everybody? Do any of the signatures look a little bit odd? Like they can bring up a forgery type defense. Does your collateral description match in the security agreement versus the UCC? Is your legal description in the deed of trust proper and match the deed? Was everything filed and recorded properly? These are things that we try to look at on the front end to try to identify potential issues and get ahead of them before we start filing things with the court. More so if it's a distressed borrower and they file a bankruptcy filing, the trustee is given a lien on everything on the day of the filing. So if there's anything missing and there's an issue with perfection, there's a problem if they file bankruptcy, because then a trustee will jump ahead of the bank's secured position, and certainly not something we want to deal with. But if we have a chance to fix it on front end before we get there, we can try to alleviate that concern. Next, we want to assess the obligation that we're talking about. Kind of hit it on a little this before, but is the bank oversecured or are they undersecured? If you're oversecured on the real property, maybe you don't have many concerns about the deficiency balance. I'm sorry, Haley, you can go to the next slide on that. If you have plenty of equity in the property, maybe you're not concerned about that deficiency, and so you're okay to simply foreclose and take it piece by piece. But if you're undersecured, you got to kind of figure out how much. Is there an appraisal done, and kind of figure out if it's worth the effort to file a lawsuit up front, or try to wait until the end to find out what that deficiency looks like before filing it. But if you know that there's a large gap, then it might make more sense to put a lot more pressure on the front end to get that judgment, especially if there's other creditors running to the court to get judgments as well. You don't want to be stuck behind everybody else. Does the bank have insurance? I know most of you that I work with, we talked about this before, and most of you are really good about doing it and checking your policies and making sure they don't lapse. But certainly, whenever you're talking about real property, it's a prime concern, especially if you have a borrower that just doesn't care and willing to put their hands in the air. They're not going to go get their own insurance policy and pay more money. They're willing to let the bank take the loss. And so we want to make sure that we're not missing anything on that front. Another part is that more of a subjective concern. Who is the borrower we're dealing with? The bank is, you have these personal relationships with these individuals, the lenders do. We already know a lot about them. We have a history of their finances. Is this a good borrower that's on tough times, or is it somebody that's got a history of falling behind, making empty promises and never following through? Some of it's going to be more of a practical consideration for the bank on whether or not to try to work with them to get things cured, or just move forward and collect the collateral because there's not much likelihood that it's going to get repaired, the relationship. And so, that can take a considerable toll on things, and you want to make sure we're looking at whether or not to take that aggressive approach or something more measured if we think that there's a possibility that we can get payments coming back in, even if we have to modify the loan. Always worth taking into consideration. And finally, again, I hinted on it before, bankruptcy filings, always ever present. Nothing we could do to stop them, but certainly once they happen, it can change the dynamics of that relationship. Number one, you have a trustee that comes in and can take a priority lien over the bank if there's issues. There's always cram down concerns where the bank is could be forced to accept lesser payments or lesser amounts over the course of the plan, and not have a whole lot of say on adjusting those terms. But in other cases, maybe we want a bankruptcy filing. Maybe we have a borrower that's got the money, just isn't good at running their business, and getting a third party trustee involved to help monitor payments that come in, especially if the bank's oversecured and you have the ability to recover attorney's fees and ongoing interest in those things. Maybe the bankruptcy could be a good thing, or a receivership or something along those lines. So not always something to be scared of. Just want to make sure that all your ducks are in a row in case we end up in that situation. And so next we want to assess the remedies. Foreclosure, it is for in rem relief only. You just get the real property. And of course you can sell it and use that money to pay down the loan. But there's no concern over the deficiency that might be existing. The lawsuit, on the other hand, is looking for a money judgment or recovery of personal property. And so that the two actions have two very different purposes that sometimes can work hand in hand with one another. Self-help repossession usually is the first thing that happens. Usually it happens before our office is even involved. Right away, if you're going to need to pick up the collateral, especially if it's a vehicle or something easily moved, quickest and easiest option. So long as you're not breaching the peace and able to get the property back without any issues, that can be a big help. Either you get the collateral and pay down the loan sum, or you get their attention and get them to cure an arrears and get back on a regular payment plan and give the collateral back. Either way, it's usually the first option to consider. Suing for money judgment, like I said, goes hand in hand with foreclosure, sometimes two different process, but a money judgment will be for the entire loan balance, typically plus attorney's fees if that's provided for in the loan documents. You can certainly do that before or after the foreclosure and credit with the net proceeds that are recovered. But ultimately, the money judgment's used to cast a much wider net of recovery for the balance. With foreclosure, you're limited to just the property and its value, which can change with the market. The judgment is a much larger, broader recovery means, because you can get the full amount owing, you get your late fees, interest, attorney's fees all included, and that lien gets placed on all property in the county it's filed in, which is good for 10 years and could be renewed for another 10 years. So you have the potential for a 20-year lien for that. And when you want to enforce the judgment, you don't need to look to the real property. You can look to any of their individual assets, some of that low-hanging fruit, cars, boats, trailers, trucks, things like that. And sometimes you find the right lever to pull to get them back to the table to start making payments in exchange for not executing and taking that property. So a money judgment can be used much more effectively, especially where a borrower doesn't really care about the real property and is willing to abandon it. Maybe they're not so willing to abandon some of their other assets that they have. But ultimately, like I said, we can do one or the other, or you can do both simultaneously. Do you want to do one first? Do you want to wait until the sale is complete before getting in default judgment? So I want to talk about some of the pros and the advantages of doing a simultaneous action. First, it can add more pressure. The logical answer here is if you have a borrower that doesn't care about the foreclosure, maybe is willing to drag their feet a little bit. Once they get hit with a lawsuit on top of it, now they have two legal proceedings they got to deal with. They got to pay two sets of legal fees. It's going to increase that urgency to resolve the matter because they're going to start bleeding money a little bit faster. And certainly it can be a little more expensive to a bank, but you can find ways to work in those overlaps to make it more feasible, because at the end of the day, you're going to shorten the overall time that you're pursuing the borrower. Rather than filing a foreclosure, getting to the end of it in 90, 120 days, 180 days, however long it takes, and then turning around and filing a new lawsuit and essentially starting over, you're going to be in court much longer fighting this person or this business. And so if we do both at the same time, you can avoid rehashing those issues. You can prepare everything at the same time. You don't have to worry about service issues down the road. Maybe we foreclose and now they bury their head in sand and go missing. And so by the time you file a lawsuit, maybe they bury their head in the sand, they're avoiding service, they've gotten a little bit wiser and they know exactly what's coming. And so if we hit everything all at once, you could try to alleviate some of those concerns that lead to increased costs. And again, if we think bankruptcy is going to be the resolution, hitting them with two simultaneous actions can certainly increase the likelihood of that happening. Most people can brush off one or the other and wait it out. But again, once they start bleeding legal fees for two separate actions, two sets of attorneys if it's needed, might push them into bankruptcy a little bit quicker to try to get everything settled. Another pro is statutory legal fees in North Carolina. It is a percentage-based award. So in North Carolina, it is 15% for reasonable attorney's fees. And that 15% is calculated on the principal balance of the loan or the obligations as a whole when you file the lawsuit. And so now if you file your foreclosure and recover your property, say you are owed 300,000 and it sells for 200 and you're left with $100,000 deficiency. So now you file your lawsuit to get a judgment on that. The 15% is going to be calculated on that 100,000 because that's how much is owing and left on the debt on the day you file a lawsuit. Now, if you wanted to do it simultaneously, your initial complaint is going to have the full amount, the full 300. So your 15% is going to be calculated at triple the rate had you waited. And so maybe at the end of the day, your judgment is going to be for less because your foreclosure finishes in the middle of the lawsuit. And that balance eventually goes down. But the law is the 15% on the day the complaint is filed. So you don't have to worry about that. So long as you file both at the same time and you have a larger debt in the beginning, you can secure a much larger attorney fee award, which again can help add pressure and stress to the borrower to try to get things resolved. And you can also reduce the risk of an offset defense. And we don't see these very often. The offset defense in North Carolina is that, if there's a post foreclosure deficiency action, and that's the key part, post foreclosure deficiency action, and the bank acquired the real property, the judgment can be challenged by the borrower or even eliminated if they can show that the fair market value of the property was equal to the amount of the debt when it was sold, or that the bid at the sale was substantially less than the true value. And the burden's on the borrower to show these things, but the idea is you don't want to have to deal with the defense if you don't have to. Certainly the bank probably will have appraisals and be bidding the appropriate amount, but just having to deal with a defense like that is going to lead to increased costs and additional hearings that you just don't want to have to deal with. So the limitation there is that it only applies to post foreclosure deficiency action. So if that action is filed before the foreclosure, that defense should not be available to them. And so sometimes you can sidestep the issue altogether. And that last point there about the 1 year statute of limitations, it's quick. 1 year comes and goes after a sale, especially if it takes some time to put the property through REO, get it marketed, cleaned up, sold, deal with any tenant issues or title issues that may have been sitting out there. And if you're not careful, that 1 year can come and go, and then you're barred from filing your deficiency action. So by filing that action a little bit sooner, you can go ahead and avoid any concerns of missing your statute of limitations. Just makes it a non-issue altogether. And just because I had to put something in there, I'll give you one con. Since I gave you all the advantages, the one con, sometimes you just want to wait and see what happens with the foreclosure, see if it's worth the effort. Maybe you're not sure what the value of that property is, or that it'll fetch what you think it will. If everything sells like you think it should, if your appraisal is current, maybe you make the money back and you got a very small deficiency balance, which is great. And maybe it's not worth it to file that action, or maybe you get more from the sale. Maybe there's a windfall. So if you file a simultaneous action before and find yourself in that situation, that could be problematic. And so if it's a close call, maybe sometimes waiting is better. But on average, typically it's not the common case that we see where things are oversecured and very comfortable. So just one thing to take in mind. And I just wanted to add one more item. I know I don't have a slide for it here, but one other issue with foreclosures to keep in mind with these deficiencies is North Carolina does have an anti-deficiency statute. Again, not something we see very often because it's very limited to mainly consumer transactions. It only applies where there was a non-judicial sale for a seller finance transaction for a consumer. And if that's the case, you're barred from getting a deficiency judgment altogether. But again, it's a rare situation, something that is certainly worth keeping in the back of your mind, certainly something to take a look at the front end to make sure that we're not in a situation where that provision would apply. But just good to know it's out there. And that's all I had on deficiencies. If anybody's got any questions, I'm happy to answer them now, or you can hold until the end. I'm happy to come back and revisit any of these ideas. But if not, I will hand the reins back over to Norman to tell us a little bit about voidable transfers and transactions.
Thank you, Thomas. Okay, so we're going to talk a little bit about voidable transactions, which are sometimes also called voidable transfers or fraudulent transfers. And essentially, this is where a debtor has transferred assets to a third party or entered into some other transaction that prevents the creditors from being able to reach their assets after a default. And if certain requirements are met, North Carolina law provides a creditor with the ability to file a lawsuit against the debtor and the third-party transferee to set aside the voidable transaction so that the creditor can realize the value of that transferred asset. We're going to talk about types of voidable transactions, the deadlines to file an action to set aside a voidable transaction, and we'll briefly touch on a transferee's possible defenses to an action. And then we'll go over a North Carolina case that I think provides a cautionary tale about the consequences of not monitoring your debtor's assets during the course of a loan relationship. Okay, so like most states, the North Carolina has enacted a version of the Uniform Voidable Transactions Act. And this act is designed to prevent debtors from fraudulently transferring their assets beyond the reach of creditors. The reason the act is called the Voidable Transactions Act versus the Voidable Transfers Act or Fraudulent Transfers Act is that it covers not only voidable transfers of assets, but also transactions that create an obligation that would have a similar effect on the creditor. For example, a dishonest debtor might fraudulently grant a mortgage or a lien on an asset to a trusted family member for no consideration to the debtor, and thereby attempt to block their creditor from enforcing a judgment lien against that asset. So in such cases, that obligation that's created by the mortgage or the lien can be set aside. If you're into history, the Uniform Voidable Transactions Act is descended from some very old laws that go all the way back to the time of Queen Elizabeth I in 1571. And some aspects of our current law even go all the way back to Roman law. So it just goes to show you that debtors have been trying to stiff their creditors forever. And unlike Queen Elizabeth's statute, however, our modern statute does not provide for jail time to the dishonest debtor, unfortunately. Anyway, next slide, please. So we're going to talk about three types of voidable transfers that are covered under the Act. There are transfers that are actually fraudulent because the debtor actually intended to defraud the creditor. And then there are transfers that are constructively fraudulent because the debtor may not have intended to defraud the debtor or the creditor, but the transfer nonetheless has the same effect of defrauding the creditor. And then we're also going to talk about preferential transfers to insiders. And this is where the debtor has transferred property to someone who's technically a creditor on account of a debt, but that creditor is so closely related to the debtor that the transfer is still unfair to the debtor's other creditors. All right, so next slide, please. So the first type of avoidable transaction are transfers that are actually fraudulent. North Carolina law provides that a transfer made by a debtor is voidable as to present or future creditors if the transfer was made with the actual intent to hinder, delay, or defraud a creditor. This is the classic situation where a debtor has defaulted on a debt or knows they're about to, and fearing a money judgment against them, they transfer assets to a third party for the purpose of removing them from the reach of their creditors. The deadline to file a claim for actual fraud is not later than 4 years from the date of the transfer, or if this 4-year period is expired, not later than 1 year after the transfer was or reasonably could have been discovered by the creditor. Now, this 1-year extension of the 4-year deadline is sometimes called the discovery rule. It was written into the law because when we're dealing with dishonest debtors, they often take steps to conceal these types of fraudulent transfers. And this extension gives the creditor a reasonable opportunity to discover and challenge the transfer. So we'll discuss a case at the very end of my section of the presentation where the discovery rules is applied, and I think provides a good example. All right. So the burden is always on the creditor to prove their voidable transfer claim by a preponderance of the evidence, but debtors rarely admit to fraud. So creditors usually must attempt to establish a debtor's fraudulent intent by circumstantial evidence. This circumstantial evidence is sometimes called a badge of fraud or badges of fraud. And these are circumstances, fact patterns that are commonly seen in these types of cases and which courts consider as being indicative of a debtor's fraudulent intent. There's no set list of all the badges of fraud that a court might consider in a case, but some of the most commonly seen ones are shown here on the screen. They include a transfer of assets to a close relative or some other insider, a debtor's retention of possession or control of the asset after it was transferred, the fact that the debtor received inadequate value in exchange for the asset, whether there had been a threat of litigation against the debtor before they transferred it or at the time they transferred it, and whether they concealed the transfer. And the list goes on. Like I said, there are many. This is a non-exhaustive list of badges of fraud. And the court will consider all the relevant circumstances when trying to determine whether a debtor acted fraudulently. Courts often say that even a single badge of fraud can warrant a conclusion that a transfer was fraudulent, but typically there's going to be several badges of fraud present in most circumstances where you have any shot of actually establishing your claim. So, but again, it's a non-exhaustive list. Next slide, please. So the next type of voidable transaction that's covered under the Act are those that are described as constructively fraudulent. Again, a constructively fraudulent transfer is one where the debtor may not have intended to defraud the creditor, but the transfer has the effect of defrauding the creditor because they really should have known that engaging in the transaction or the transfer was going to put the creditor at risk of non-payment. And the North Carolina voidable transaction covers two categories of constructively fraudulent transfers, which are somewhat similar to each other. And the first type of transfer are those that are voidable as to present or future creditors if the transfer was made for less than reasonably equivalent value at a time when the debtor was engaged or was about to engage in some business or transaction for which their remaining assets were going to be unreasonably small, so that they stood a high likelihood of not being able to pay the creditor, or where the debtor knew that they intended to incur or they believed they would incur debts beyond their ability to pay. We don't often see cases fitting the latter description. Usually it's because the debtor already had obligations or loans making this transaction unreasonable and constructively fraudulent. Now, the deadline to file a claim for this type of transfer is 4 years from the date the transfer was made or the obligation was incurred. Next slide, please. All right, so the second category of constructively fraudulent claim covers circumstances where a debtor made a transfer or incurred an obligation without receiving reasonably equivalent value in exchange at a time when they were already insolvent or they became insolvent as a result of the transfer. This is a more common fact pattern that we do see where they were already insolvent, whether or not they had already defaulted on a debt with a creditor or not. This type of claim is typically brought in addition to a claim for actual fraud under the first part of the statute that we discussed at the beginning of the presentation. Again, the deadline to file a claim based on this type of transfer is 4 years from the date of the transfer. And I'll just point out also that interestingly, this type of claim is limited to only present creditors who were owed a debt at the time of the transfer. So it just reflects the fact that future creditors who might loan money or extend credit after the date of a transfer are really doing so at their own risk. They're under the obligation to do their own due diligence to determine whether a potential borrower is solvent before deciding whether or not to lend money to the potential borrower. All right, next slide, please. So the last type of voidable transaction covered under the Act are preferential transfers to insiders. And the Act provides that a debtor's transfer to an insider as payment for a debt is voidable as to present creditors if the debtor was insolvent when the transfer was made and the insider who received the transfer had reasonable cause to believe that the debtor was then insolvent. And the Act actually includes a very specific list of relationships that make a person or an entity an insider to the debtor. And generally speaking, those relationships include close family members, business partners, and certain related entity relationships like parent subsidiary, that sort of thing. So as an example, this part of the Act covers the classic situation where a debtor owes a legitimate debt to their spouse who is aware of the debtor's precarious financial position. And instead of the debtor using that asset to pay their debts to unrelated creditors, instead they pay the asset to the spouse. They prefer the spouse, and that's why it's called a preferential transfer. And the deadline to attack this type of transfer is quite a bit shorter than the other types of avoidable transactions. It's 1 year after the transfer was made. So the Act provides a number of remedies for avoidable transfer claims. Generally speaking, you can seek to set aside the transfer to the extent necessary to satisfy your debt. At the outset of an action, you can seek an order to attach the asset that was transferred or enjoin the transferee from disposing of it or transfer it on to other parties. In some cases, you might be able to get an order appointing a receiver over the asset who can then sell it and use the proceeds to pay your claim. And if you already have a judgment against the debtor, you might be able to get an order allowing you to have the sheriff levy against the transferred asset or its proceeds directly. Next slide, please. So just very briefly, the transferees do have some defenses under the Act. The most common defense is where actual fraud has been alleged, and the transferee will allege that they took the transfer in good faith and paid reasonably equivalent value to the debtor. And if they can establish this, that they didn't have any reason to believe the asset was transferred to them with fraudulent intent, and they did pay a reasonably equivalent value, then they have a complete defense to avoidable transfer claim. Now, in cases where a creditor's claim concerns constructively fraudulent or preferential transfers, the Act does contain various defenses that are applied in some very specific circumstances. These are generally more limited defenses because usually the transferee didn't give reasonably equivalent value, or they were insiders who had reason to know about the debtor's insolvency. So again, there are some very specific defenses in the Act, but a complete discussion of those is really beyond the scope of this presentation. So next slide, please. All right, so the discovery rule, as I mentioned at the outset, when we're dealing with a claim of actual fraud, that the debtor actually had the fraudulent intent to transfer this asset, I want to discuss the discovery rule a little bit more in depth, because I think it's important for creditors to understand how their own procedures can affect a deadline to file a claim. You'll recall that when the claim is based on fraudulent intent, it must be brought within 4 years after the date that the transfer was made, or if the 4-year period has already passed, a creditor can still bring a claim within 1 year after the transfer was or reasonably could have been discovered. Now, there was a significant case back in 2016 before the North Carolina Court of Appeals called KB Aircraft v. Berry. And I think it really serves as the cautionary tale for creditors. In the case, a lender had obtained a $10 million judgment against a loan guarantor named Jack Berry. The lender obtained the judgment in 2013. The lender who sued Berry had actually obtained the judgment, had actually purchased that loan from another lender who had originally made the loan to Berry. Now, when seeking to collect on the judgment, the new lender found out that back in 2008, Berry had actually transferred a $4 million vacation home to an LLC in which his wife and him were the only members. The lender filed a new lawsuit against Berry and the LLC seeking to set aside the transfer and impose a judgment lien against the vacation home. And Berry had transferred the vacation home after he'd actually already defaulted on the loan and was under a forbearance. And the deed showed that he transferred the home for no consideration. So there were very good grounds to allege that the transfer had been actually fraudulent. Since the transfer was more than 4 years old, the new lender sought to take advantage of their 1-year discovery period, the discovery rule. But during the litigation, it was shown that Berry pursuant to his obligations under the loan documents, had periodically provided the original lender with his personal financial statements. And at least one of those financial statements submitted in 2008 listed the vacation home as one of Barry's assets. And then later statements after 2008 omitted the vacation home and actually showed that it was now owned by the LLC. So based on this, Barry asserted that the lender's 1-year deadline under the discovery rule had already expired because the lender reasonably could have discovered the transfer by just reviewing his personal financial statements. Both the trial court and the Court of Appeals agreed with Barry, unfortunately for the lender. They held that if the original lender had compared and closely scrutinized Barry's financial statements from year to year, there was enough information in there to put them on notice that he had transferred his vacation home to the LLC. And as a result, the successor in interest who bought the loan from the lender was bound by those actions. And they were not allowed to take advantage of the 1-year discovery rule because it actually run before the loan was ever sold to the original lender. And then the 4-year period after that also expired. So I think the takeaway from that case is that, the court stated that a lender has a duty to exercise reasonable diligence to discover a debtor's fraud or misrepresentation whenever some event occurs or they acquire some knowledge or information that would put them on notice of a potential claim. And in this case, the creditor's own procedures of collecting their guarantor's personal financial statements was enough to put them on notice of a potential fraudulent transfer claim. They failed to act within 1 year after acquiring that information, so they lost out. Now, this is not to say that lenders should not collect the personal financial information of their borrowers. They certainly should. It's a valuable tool to monitor their debtors' creditworthiness. But if they're going to collect that information, then they need to scrutinize it. And if there's information contained in those documents to suggest there has been a voidable transfer, then the creditor should consider acting on it. And if they don't, they should understand that they may lose the right to do so. And I would just also lastly point out that lenders don't typically engage their outside counsel to review a debtor's personal financial statements when a matter is initially referred for collection or foreclosure. So a lender's outside counsel would not be aware of a potential voidable transfer claim in many cases. So if you have a debtor's personal financial information in your loan file and you're unsure whether it was closely reviewed when it first came in, then it's definitely a good time after default to dust it off and scrutinize it for evidence of potentially voidable transactions, and then discuss that information with your outside counsel. All right, so that, I think we've covered voidable transactions. I'll just hand it back to Thomas.
Yeah, thanks, Norman. Really good advice about those financial statements. They all look like Greek to me sometimes, but goes to show you got to take it seriously if you're going to collect those. Piercing the corporate veil. This is a more awkward remedy, which can be difficult to prove, but sometimes it may be the best way to recover, or really the only way to recover on a debt. Generally, what we're talking about here with piercing the corporate veil is you're looking for a situation where somebody is ignoring those corporate formalities or commingling assets between entities and themselves, or just doing something that just doesn't look right from a corporate standpoint, which would give the bank the ability to quote unquote pierce the veil and get at LLC or corporate assets for obligations that are owed by an individual or a separate business altogether. So as it says here, piercing a corporate veil, it's imposing that personal liability on the officers, the shareholders, the members for the obligations of the LLC, which is, as you know, the whole purpose of forming an LLC is to create that shield, to get that protection as a business owner so that creditors can't get at your personal assets for you just operating your business. But, the principle here, as it says, you're supposed to have separate entities between corporations and LLCs and keep things separate and follow those formalities. Veil piercing is the exception that allows you to break into the personal accounts and assets of an individual because they're ignoring those norms. They're not using the LLC like it's intended to be used, and so as a result, they lose that protection. In North Carolina, we have what's called the instrumentality rule, which I believe is the majority rule across the country. So that's the legal standard here. It looks at three main ideas. And Haley, you can go to the next slide, please. First being dominion and control. So we're looking at control by the owner that's so complete that the corporation has no separate entity, business, mind, or will of its own. So what we're thinking about here is you have a sole owner, member, manager of an LLC, right? There's an LLC and there's just one guy running it. That's his show. Now, is that a piercing the corporate veil problem? Not necessarily, but when taken into account with other things, it can certainly be a red flag. You know, maybe there's no separate bank account. You know, they're just using this entity as their personal or piggy bank, right? That's where all the money goes in. They use the corporate card for personal expenses. Maybe they bought a car using the business money. It just shows that they never really formed this LLC for its intended purpose. They're just using it as their own. And so that's what allows the law to break free and pierce that veil. Improper conduct, kind of just already hinted on it, but you know, they're getting these loans, they're not paying on them. They're using the funds in a way they're not supposed to. And the proximate cause part goes hand in hand. It's your payment default. So that's what allows you to get at them for mismanaging the company, essentially. And very similar to what Norm was saying before, you're looking at circumstantial evidence here. There's not going to be a silver bullet to find that says, uh-oh, they've messed up and now we should be able to get their assets, case closed. So next slide, Haley. You look at this sliding scale, this non-exhaustive list of factors has been put out by courts, but it's not everything. It's more of a guideline of some of the red flags to look out for when you're doing your due diligence, when you're looking at their business records and trying to figure out how things are managed. These are the things to look out for. You know, inadequate capitalization, number one. You know, how's the business running? Ignoring those corporate formalities. Could be something as simple as not filing your annual forms with the Secretary of State's office, not holding meetings, not, you know, following your own bylaws, or articles of incorporation. Maybe they're not filing tax returns on behalf of the business, not preparing those standard financial statements and budget reports that are required. If you as lender are asking for these documents as part of the requirements of a loan and not getting them, maybe they're just bad at business, but maybe they've not been following these corporate formalities, and it should come as a quick red flag. All the more reason to make sure you're, you know, doing your due diligence and asking for these records at the appropriate time to make sure they're following up on these things. And if they're not, you start building the case towards a piercing the corporate veil down the road. Complete domination, such as no independent identity. This is like I was saying before, this is where maybe the guarantor is making all the decisions for the business. He's the sole member manager, sole owner, shareholder. He's not following the bylaws. He's not doing anything under the governing documents and just running the business how he sees fit. Kind of takes away that independent identity. You know, the statutes have enacted that businesses are their own person, so to speak. And if they're being completely controlled by one person, then there is no independent identity. They're supposed to operate independent of the individual and follow those bylaws as the guidelines. Commingling funds, assets, that's probably one of the biggest ones we see. One of the biggest red flags. That's using it as their own piggy bank. That's the business owner that's getting all of his personal items through the corporate account, using those funds as his own. So in the eyes of the law, there's no reason that account should not be considered his own asset. if that's the way he's using it, it's not being used for business assets, it's not being used for business expenses. That's what allows you to get at it. Again, using it for personal use, fraudulent misrepresentations, if they have a history of making, fraudulent statements or providing fraudulent corporate records to the bank, shows they never really intended to operate the business as it was intended to be. But yet, in general, they need to have separate bank accounts. Most businesses will have an operating account, a payroll account, and they certainly don't use it for their own personal gain. And so finally, the excessive fragmentation of a single enterprise, that's one business, but there's multiple LLCs, each with their own arm. Maybe they have all their assets entitled in one name, another name has all the liabilities. And this happens sometimes without lenders realizing it because they name them so similarly. And when loan documents are executed, those names kind of get swapped in and out and can confuse things. So you got to be careful when people are just fragmenting their business into separate entities to all have their own separate individual responsibilities. Next slide, Haley. So when is veil piercing available to a bank to consider? And I think it's pretty broad, but essentially you're looking at the misuse of the legal entity. You're looking for all those badges to steal from Norm's prior presentation. All these different factors, these badges that all build up into one pile to show that they've been using this wrong to perpetrate a fraud. And they're just using this entity as that alter ego. Never really intended for the business to be its separate thing and grow and become anything more. It's merely just being used as their own alter ego. That's going to be the underlying current, what you need to look at. But it's not an easy thing to show. It's because there's no silver bullet that says that they were doing this. You got to build up the case. You got to get that evidence. And a lot of that evidence is not readily available to the bank. You're limited by the documents you've been being provided over the course of the relationship. And so you might have some breadcrumbs that are leading you there, but it's very hard to make a determination right out of the outset that, this is going to be a clear-cut case. In fact, I don't think I've ever said the words a clear-cut veil piercing case because it is a bit of a coin toss. But you need more than just a single member entity. Yes, that's a problem. Or they didn't pay their debt or capitalize properly. It's a shifting scale. You got to build up the case and show more than just one thing. And it can be kind of a high bar depending on what court you're in and who your judge is. They all look at it differently. There's no set amount of factors you need to check the box for. So one positive note is that this is not limited to just LLCs. It works for corporations and LLCs equally. So we're not just talking about the LLC protections. We're talking about just businesses in general. So thinking strategically. Next slide, please. I think I already kind of talked about what those warning signs are. Read your documents, pay attention to things. If things don't seem right, if it appears to be a sham or a shell corporation, you see assets being moved, likely attempts to avoid liability. They're not providing the proper forms when requested. If you're getting bank statements, if you're starting to see things that don't really make sense for a business to be purchasing, did they buy 2 cars last year for a business that has no reason to use company vehicles? These are warning signs, and so don't just write them off. Take note, and as they pile up, certainly is something to consider, and it might come back to help you out in a later lawsuit. And when to use, next slide. Judgment enforcement is going to be the primary vehicle, but it could also just be for leverage in a litigation. Normally, you're just trying to get assets, and if your individual has no money, maybe they're judgment proof, every asset is tied up in the business, well, that's who you want to go after, but they didn't sign the loan document. So if you can find a way to pierce the veil, now you have a way to get some assets and get some actual recovery because the borrower was trying to be sly and put all their assets in the business's name. But if you can pierce that veil, now extends your reach to get at those assets, whatever they are. And leverage is another important part. Like I said, it's not easy to prove. It's easy to allege, and once it's out there, you got to see it through in the lawsuit. You got to be diligent. You got to do your discovery. But more importantly, that discovery is going to require them to do a lot of work, and they're going to have to defend against these allegations. And so there's a lot to be involved. There's a lot of culling through corporate records that they're going to have to provide to you. So something to be considered in a litigation, even if you don't want to see it through to the end. If you think there's some smoke there, think it's worth it. It's worth considering, because if we can pressure them in litigation, maybe we get them to come to the table and talk through a settlement a lot sooner, so we don't have to fight over these issues. This is typically a trial type issue. This is not something that can be resolved easily up front. The parties are going to have to spend a lot of money going to the mat on this, and that can be a lot more of a motivating factor for the other side than anything else. I know we're running low on time, so I just want to run through a couple of quick considerations on top of that. The burden of proof's on the creditor. So if we're going to file that claim, you got to have a good faith basis for it and think that there's, some fire where you see that smoke. But you got to be able to flesh out the whole picture, and it can be very costly. There's significant discovery involved. You're probably going to need to take a deposition of different officers and bookkeepers, usually multiple parties. Written discovery, because you're going to need to get every bit of financials and business records you can get your hands on. Chances are you're not going to get it in a nice organized package, and it's going to be a bit of a mess. So there's going to be a lot of time and effort combing through the records to find out what exactly is going to help your case or what's going to hurt it. But the evidence is going to have to be strong. It's not an easy claim to bring. You're kind of dependent on how that judge is going to rule and whether they think you've met that burden and provided enough information to show that they should ignore this corporate formality in the law and allow you to get these assets. And so just be warned that it can be an expensive claim. It could be a long-term issue to go through, but sometimes it's your only option. If you have a judgment-proof debtor and they don't have any assets to go after, and you got the ability to bring these claims, it might be worth it. You might end up settling for something from them, or if you have to go through to the end, maybe there are some assets in the business's name that make it worthwhile. So just a couple of things to consider on the front end before jumping in with both feet. But I know we're running low on time. I don't know if anybody had any other questions about any of these presentations, but happy to do a quick fire response if you have anything. All right. Well, hearing none, I want to thank everybody for taking the time out of the day and joining us here. It's been great. Thank you, Haley, for all your help as well.
Sorry, I was muted. Of course. Thank you all for attending. Thank you, Norman and Thomas, for this very detailed information. Please save the date for our final webinar on this series, which is going to be Wednesday, August 27th. That is going to be regarding special topics in bankruptcy and receivership with Jamison Dobb and Paul Fanning, both from our Greenville office. I'll be sending out information on that in the next week. Tomorrow, you'll receive this slide deck in your inbox along with the link to this recording so you can share with your friends and colleagues. That is going to conclude today's webinar. Thanks, everybody.